I'm Attorney Charley Wood, and I'm the Chief Operating Officer and Managing Partner of Attorney's Title Services. We're a national title company based out of Jacksonville, Florida. In this instructional video, we go over what is title insurance, what is a title commitment, the common title endorsements, and how to read the title commitment. So the first question we often get asked is, what is title insurance? So title insurance is an insurance policy that covers you if title problems come up after you buy or refinance a property. Possible complications include lost, forged, or incorrectly filed deeds, property access issues, and liens on a property. And a good example of this is if there is an unpaid mortgage on the property that you just bought, you may be held legally responsible. Without title insurance, you might have to pay the legal costs to settle the dispute. If you lose the dispute, it could cost you money, the equity you have in your home, and perhaps even the ownership of the home. Title insurance is designed to cover associated legal costs to settle the dispute and or to resolve the problem. Now there's two types of title insurance. There's the owner's policy and the lender's policy. The owner's policy protects the homeowner, for the full price of the home plus legal costs if title or ownership issues arise after you buy your home. This type of policy is issued for the amount you paid for the home and will cover you as long as you own an interest in the property. The other policy is the lender's policy, and it only protects the lender if a title issue or ownership problem comes up after the property is purchased that affects the lender's lien position for the mortgage. The lender's policy is issued for the amount of the mortgage, and unlike the coverage for the owner's policy, it decreases as you pay down the loan. And ultimately, when the loan is paid off, the loan policy goes away. And most lenders will require you to have a lender's title insurance policy as part of a loan transaction. Title insurance rates are set by the state of Florida, and they're contained in the Florida Administrative Code pursuant to the rules of the Florida State Treasurer and Insurance Commission. And the way that the premium is calculated is based on a per thousand cost. So any policy up to $100,000 is $5.75 per thousand. And then from $100,000 to $1 million, it's $5 per thousand. $1 million to $5 million is $2.50 per thousand. And from over $5 million to $10 million is $2.25 per thousand. And anything over $10 million is $2 per thousand. So for example, a $100,000 title insurance policy costs $575. And a $200,000 policy would cost $1,075. In Florida, we also have a thing called a simultaneous issue fee, and this is where a loan transaction is involved with the sale of the property. Florida allows a discount on the lower price title insurance policy called a simultaneous issue fee. So for example, if the sales price is $200,000 and the loan is $150,000, the owner's policy for the sale price would be charged at the full state set rate, which would be $1,075 for the owner's policy, but the loan policy will be charged a discounted rate of $150. In the state of Florida, we have 4 common title insurance endorsements that go along with the lender's title insurance policy. They're the 4.1, the 5.1, the 8.1, and the Florida Form 9. The 4.1 and the 5.1 go together. One is for a condominium endorsement, one is for a planned unit development endorsement, or homeowners association endorsement as it's often referred to. So 4.1 covers the condos. It ensures that the unit is part of the condominium documents comply with state requirements, there are no violations or restrictive covenants, and that the documents contain no provisions which cause a forfeiture or reversion of title, that the mortgage has priority over liens for charges and assessments, that the unit will be assessed as a separate parcel for real estate taxes, that there is no obligation to remove any improvements due to encroachments, and that there has been no right of first refusal which would defeat title. And the other one, the HOA endorsement, the endorsement 5.1, is the same, except it's for homeowners association properties, planned unit development property. And of course, if you're not buying a condo and you're buying a house that is not within a homeowners association, then neither of these would apply. The other common ones are the 8.1, it's the environmental protection lien endorsement. This provides limited insurance that no environmental protection lien has been filed of record or provided by state law as of the date of the policy that has priority over the mortgage. And Florida Form 9 is restrictions and encroachments. This endorsement provides insurance against loss or damage resulting from the violations of deed restrictions, encroachments, and setback lines existing as of the date of the policy. So with every contract in the state of Florida, whether it be the FAR Bar contract, the Florida Bar, Florida Realtors contract, or the Northeast Florida Association of Realtors contract, it all provides a provision in there for the delivery of the title insurance commitment. And what the title insurance commitment is a document that sets out the rules for the road of your transaction, provides a guidance on what needs to be done in order to convey clear and marketable and insurable title. The parts of the commitment are Schedule A, which describes who and what will be insured, Schedule B1, which sets out the items to be cleared, created, or resolved in order to insure title, and Schedule B2, which lists the exceptions to coverage. This is a standard American Land Title Association title commitment that the underwriters in Florida use, and this is one based on one that was prepared by Westcor Land Title Insurance Company, which is one of our underwriters. So Schedule A lays out the who and what of the transaction. So it has the state and county of the property address that's being sold. It has the underwriter's plant file number, the title agent's file number, the effective date of the title commitment, which this is the date that the public records were current as of the date that they did the search on the property to create this title commitment. Right here it has the policies that are to be issued. It has a owner's policy to John Smith and Jill Smith, who would be the purchasers of the property, for $270,000. So $270,000 would be the purchase price of the property. We have a proposed loan policy to Giant Global Mortgage for $200,000. So in this one, the lender would be Giant Global Mortgage, and the loan would be $200,000. Down here we have the state or interest in the property. So this would be either fee simple or leasehold interest in Florida. Fee simple means that the owner has clear ownership to it. Leasehold interest would be that the person selling the property has a lease on it, such as a 99-year land lease. So this one here is fee simple, so they have the full fee simple ownership to the property. This one on here on number 4 shows us title to the estate or interest in the land as of the commitment date is vested in, and this would be who the seller should be. So these are the people who actually have the ownership as of the date of this title commitment, and this has Sam Jones and Sue Jones. So on this contract, Sam Jones and Sue Jones should be the seller, and if it's someone else, you know there's an issue. Section 5 has the land is described as follows. It says see attached Schedule A continuation of legal description. For really small legal descriptions, they would be in here. If the legal description is bigger, they would be on a separate page. And then it has a place down here for the title agent to sign, which would be us, Attorneys Title Services. And then here's the continuation page. So this is the full actual legal description of the property that's being sold. Lots 29, 30, 31, 32 of Block 24C of Happyville Estates, according to the plat thereof, is recorded in Plat Book 800. Pages 23 through 25 of the current public records of Duval County, Florida. Schedule B, Section 1 tells us what we need to do to be able to convey clear title as part of the closing. So it starts out with documents satisfactory to the company to convey title or create the mortgage to be insured. So it tells us right here we need to get a warranty deed from the current owner to the proposed insured owner conveying the land. We need to get a mortgage from the proposed insured owner, so the buyer, to the proposed lender that would encumber the land. It has notice on here for us that if there's any spouses involved that aren't on title and that this is homestead property that the spouse has to join, or we need to include non-homestead language if it's non-homestead. It says pay the agreed amount for the estate or interest to be insured. So this is make sure that the buyer pays the seller. Payment of taxes, charges, assessments levied against the subject property which are due. So this is make sure any past due property taxes are paid, any special assessments or anything like that are paid. Next one here is satisfactory evidence. Should be had that all improvements or repairs or alterations that are completed, that contractors, subcontractors, labor, and material men are paid. Basically, if there's been any work that's been done on the property, that everything's been paid for. The next one tells us Section 3 and 4, which we'll go over. Of Schedule B, Section 2 may be amended or deleted from the policy to be issued if a survey satisfactory to the company is furnished to the company. What this is provided that there is a clear survey showing that there's no boundary and encroachment issues, we're able to remove the survey exceptions, which we'll go over on the next page. Number 6 on here says release or satisfaction of the mortgage to be executed by the owner in favor of, and has the mortgage company. So this would be an existing mortgage by the seller. Lets us know that we need to get a release or have it satisfied from the public records. Down here is satisfactory evidence that all homeowners associations dues or assessments, including any special assessments against the land, the property that's being sold, are paid in full to date. So with that, we need to get a estoppel letter from the homeowners association to verify that everything is current. And the last one here is pay the premiums, fees, and charges for the policy to the company. So make sure that the fees for the owner's policy and the lender's policy and the endorsements are covered and paid to the title insurance. Schedule B Section 2 goes over exceptions to the title policy, but a little hard to see here, but 1 through 5 are considered the standard exceptions in Florida that we're able to remove with an owner-seller affidavit, provided none of these things exist. So the first one is defects, liens, encumbrances, adverse claims, or other matters, etc. We would have the seller sign an affidavit attesting that none of these exist, and if that is true and they sign it, we're able to remove that as an exception. The second one is rights or claims of parties in possession not shown by the public records. So if this is owner occupied and the owner is selling it to the buyer and there's no tenants, we'd be able to remove this one. 3 and 4 go with the survey. The first one is any encroachment, encumbrance, violation, variation, or adverse claim affecting the property, as well as easements or claim of easements not shown by the public records. With a clean survey showing that there are no issues with these, we're able to remove those, so that way if later there wound up being a survey issue, the title insurance policy would provide coverage for it. Number 5, taxes or special assessments which are not shown as liens existing by the public records. So this is us just making sure that any back property taxes are paid, and that if there are any special assessments, they are paid as of the date of the policy. We'd be able to remove that one. Number 6 here says taxes and assessments for the year 2018 and subsequent years which are not yet due and payable. With this one, we'd verify that the 2018 taxes were paid. We would keep this, but we'd modify it to 2019. So that way any 2019 taxes wouldn't be covered, but any taxes predating that would be covered. Number 7 on here, we're able to remove with a clean municipal lien search showing that there is no past due water or sewer amounts, there's no special assessments, there's no code violations, anything like that. With a clean municipal lien search, we're able to remove those. The next two, 8 and 9 on here, we're not able to remove because they run with the land. The first one is restrictions, reservations, setbacks, and easements, and it goes through the plat, book and page number. So this is the plat that was recorded in the public records of Duval County for the neighborhood, such as where you can put the house and any setback lines and stuff like that. These are things that run with the land and you cannot remove. Number 9 on here is restrictions, reservations, covenants, and conditions pursuant to a certain instrument recorded. And the key for us on here, it says provides for a private charge assessment. This is the homeowners association restrictions, reservations, and covenants and conditions that are filed. So if you buy a house within a homeowners association, you're required to abide by their rules. The last section down here has a note about property taxes and lets us know that the property taxes of the year 2017 were paid and the amount that was paid. It also gives us the assessed value of the property and what the gross amount of the taxes were. The last section on here has the ownership chain for the last 24 months of the property, and if there was no changes in ownership in the last 24 months of the property, the underwriter will put the last deed of record. So as you can see on this one, the last deed recorded was May 31st, 2006 into the seller of the property. Had this been a foreclosure or an investment property and there was several transactions occurring within a 24-month period, they would all be listed on here. But since nothing occurred during that one, the last change of ownership for this property was May 31st, 2006. I hope this instructional video helped you better understand what title insurance is, the costs involved, how to understand the title commitment, and the common title endorsements in Florida. Of course, if you have any questions, please feel free to email us at info@atsclosings.com or give us a call at 904-260-0105.